Yes. Okay, let's start. So first about myself, I am advocate Girish Rao. I'm advocate and solicitor. I'm having more than 27 years of experience now, and my practice area is real estate. So this is something right from the day I started my practice knew about this topic. So that is how I'm conducting this webinar. And I've been conducting webinar for last 2-3 years on various topics. Some are paid webinars, are basically for advocate. Rest are free webinars like this, which are for general purpose for people to know about the topic. With this, now let's start about today's topic on deemed conveyance. How many of you are aware about the deemed conveyance? Just put in the chat box aware if you are aware. If not aware, put NV. NA, not aware. I want everyone to participate. That's only when you are going to know about the topic. And only those person who continue till end are going to get a gift from my side. Okay. So that I get an idea about it. That's the reason why I'm talking. Okay. So we are going to in this webinar explore all type of conveyance. Reason I'm talking all kind of conveyance is conveyance in respect of a building which is isolated, only one building, one plot, nothing else. A conveyance in respect of plot where there are multiple building, multiple societies. Even that we are going to cover. So let's now begin with this topic of deemed conveyance. Let me do screen sharing. All are able to see the screen? All are able to see the screen?
Yes.
Yeah. So now, when we are talking about the deemed conveyance, the first thing which we have to know is that what is this conveyance? That's the first thing which we should know. When we talk about conveyance, means basically it is nothing but transfer of property from one person to another person by a document which normally in our legal parlance, which we call as deed of conveyance. Deed of conveyance is normal. It can be also sale deed also. Sale deed and sale deed or transfer deed, it's all same. It's a deed of conveyance only. Only names are different. But sometimes transfer deed is a name given for other than sale deed also. Like a trustee transferring the property to the beneficiary. That is altogether a different topic. On that topic also we are going to have a webinar on it. So now at present, what is a conveyance? Means one person transferring that one property to another property is a conveyance. And it is for a consideration which is decided between them. So that is what basically a conveyance is. Right? So now, why is conveyance required? Today we are talking in respect of a cooperative society or a association formed under Maharashtra Ownership Regulation Act. In respect of that, we are talking today. That is our topic. So those are basically typical how the transaction takes place. You enter into an agreement with the developer to purchase a flat. So there is an agreement with the developer that you are going to purchase a flat. Suppose the flat cost is, let's take for 1 crore rupees. So you agree with that. you are going to purchase that flat for 1 crore rupees. Rakesh, just mute them, everyone. Rakesh
Okay.
Pallavi.
Yeah.
I think just hold on. If I'm not made you this thing, let me make you co-host. Just hold on. Huh? Just a minute, give me. Yeah. Sorry. So what is the topic? I was explaining that you agree to purchase a flat. So that is the only thing what you agreed is to purchase a flat. So you will become an owner of that flat. That's what basically an agreement between you and the flat purchaser. But if you are aware that typically that's an agreement for sale, there is no finalization that by way of any transfer deed or sale deed. You pay your entire amount, whatever is agreed between you and the flat purchaser. And after once he completes the building, he hands over flat to you. So there is no further document, there is no sale deed, no transfer deed, nothing absolutely. Where is ownership document? You have no ownership document. So in Maharashtra, we have a one act is MOFA, which is Maharashtra. I'm not going through that long this thing. It's a very long Maharashtra ownership regulation and those are. It's which in short term we call as a MOFA, which already I have posted on the group. That is one act which is MOFA, which is applicable, which was applicable up to 2017. Then in 2017, RERA came into picture. So now two acts are applicable for this kind of transaction. One is MOFA, one is RERA. What it contemplates is that all flat purchaser will become a member of an association. So for our discussion right now, I am keeping it as a society. It can be also company which is association which is formed. It can be apartment owners association also. It can be. It depends upon what agreement which is there between builder or what is the concept of the builder. It depends upon the yourself. So it depends upon case to case basis, whatever. But for our discussion, we will discuss it as a society, but same law, same process is applicable for deemed conveyance from for conveyance in respect of if it's association, it's company. Same process will be applicable with minor changes, right? So, but why it is so? Because what happens is that you purchased a flat, though there is a document which makes you owner of the document, but let's just for agreement for purchase is there, for flat sale is there. With that, you have acquired that flat. But that you are owner or you will be taking care of your flat. So who is going to take care of all common amenities like water, sanitation, common electricity, many other things? For that purpose, it is mandatory for all flat purchaser to become member of the society. Section 12 of MOFA deals with that. It is mandatory. And section 19 of RERA talks about it. It's a mandatory. So mandatory means every person has to become the member of the cooperative society. A person cannot say that, no, I am not going to become a member. I am not going to do anything, or society cannot say that I am not going to make you member of the society. It's a mandatory. There's absolutely no choice. Society has no choice to not to make other person as a member, nor other person has a choice not to become as a member. And it is beneficial for both.
I took a back seat.
It is beneficial for the both flat purchaser and also the society also. Suppose a flat purchaser doesn't pay proper maintenance. In that case, as it was earlier, if it is not member, they could have not gone under section 101 of the Cooperative Society Act. But now there is a change in the Cooperative Society Act by way of amendment in 2019. In 2019, if you see it properly, you can make an application. I think section 154, 154A something, 28 something like that. So you can make even application against the occupant also, not necessarily only against the member. If you read it properly, but that is not a topic now. But basically what I'm saying is that it is mandatory for both the parties, means flat purchaser and the society also, to make the flat purchaser as a member of the society. So you become a member of the society, you become entitled to your flat. But what happens to all the properties other than your flat, your building, common area? There would be, if it's a bigger complex, maybe clubhouse, all other amenities and all those things. For that purpose, the property, means the land on which your building stands and the building is supposed to be conveyed by the flat purchaser, by the builder or the landowner, as the case may be. We'll discuss all the things to be conveyed to the society. Is it clear up to now? Any questions? Those who have any question can ask the question. Just unmute yourself and ask the question, or you can put in the chat box also. My colleagues who are Rakesh and Pallavi are there here. They will then forward it to me. Any question, anything up till now? Okay. No questions. So you understood whatever I spoke up to now. Put in the chat box if understood. Yes, why yes. I want all of you to participate so that I understand whether you have understood or not, so that if any changes has to be made, I will make the changes. No, I am not. Yes, understood. Chalo, let's proceed. Few answered yes karke. No one here answered no. Okay, let's proceed. I want everyone to take participate in the discussion, so that it will be more fruitful and everyone will understand in a much better way. Okay. So why conveyance is required? It's now clear. Because only when conveyance is done, you become an owner of that land and the building. Otherwise, it's a builder or developer who has constructed is a technically owner of that property. Now question comes, what is deemed conveyance? See, under section 11 of the MUFA, And now even under RERA, but RERA is not coming in discussion of deemed conveyance, because RERA doesn't contemplate any deemed conveyance. But under section 11 of the MOFA, it is an obligation of the developer to convey the property to society within a prescribed period. If any period is not prescribed in the agreement, then within 4 months from the formation of the society. However, what was happening was that builders were not conveying the property. So when builders were not conveying the property, the normal course would have been, means that had to be followed was either file a suit in the civil court or file a complaint in the consumer court. So there was a lot of limitation, and you are aware of our legal system, which takes years to dispose it of. And again, once you may get a decree thereafter appeal, and those procedure used to be very cumbersome. So that is the reason the government in 2008 amended MOFA, and provision for deemed conveyance was introduced. What happens in the deemed conveyance is basically, in normal conveyance, what happens? Normal conveyance, a document, a conveyance is executed by an owner who conveys the property to the purchaser. That is our normal conveyance. But when it comes to deemed conveyance, it is a sub-registrar or his authorized officer who conveys the property. So in conveyance, normal conveyance, it's the owner who conveys the property to the purchaser. In deemed conveyance, what happens is that sub-registrar or its authorized officer executes the conveyance in favor of society after following the procedure which is prescribed. That is what basically today we are going to discuss. Now, I have heard many times, many places, why should we get property conveyed in our name? Who is going to do us anything? See, you become owner of the property only when there is a proper conveyance of the property, when property by way of conveyance become transferred to you. Otherwise, you are not owner. Society is not owner. Many times I see we are for 12 years, more than 12 years, we are staying there. So we need not do anything. We become owner. But yes, you become owner. But what is that to show that you are owner of the property? Do you have any document? Adverse possession, that is not required to be done. Adverse possession, but who is going to decide whether you were in adverse possession, whether you were in possession for 12 years, or what is that? What is a document do you have to show? You have to show that you are a owner of the property. Absolutely no document. Suppose something happens, like in Turkey, there was an earthquake, building collapsed. So with building collapse, who is going to give you permission if you don't have a conveyance? If there is a building collapses, nobody is going to give you permission because you are not the owner of the property. Similarly, if you want to do redevelopment or you want to do anything on that property, suppose there is an open space around, you want to do some construction, do something over there. Municipal corporation is not going to give you any permission unless you are owner of that property. Understand this. If you are not owner, you will not be able to do anything in respect of property. That is why it is very important to get property conveyed in the name of society. If not, you don't know when you will face any difficulty. So it's most important document which is ignored by many of the societies, because managing committee member think no, it's not required. Some are very intelligent. They will say nothing is required. We don't have to require any conveyance or anything. We are owner. Who is going to stop us? It's not. You have to get your property conveyed. You should become an owner of your property because you have paid crore, maybe lakhs. Now nothing happens in lakhs. One nowadays flat cost is minimum a crore. So that is what is required, that you pay so much amount and you are not a owner of your property. Therefore, conveyance is important. So now let's see what is the procedure for conveyance. Any questions up to now? Any questions? No questions? Then type yes, why yes, so that I understand you are understood. Thank you, Kiran, Pushpa, Divakar, Prachi, Sumi, Vibhu, Mayur. Sorry if I spelled out wrong name. Sachin, Narayanan, Pradnya. Okay, I will show you a slide of deemed conveyance. Sripad, thank you. Okay. Just wanted to see slide of deemed conveyance, right? Nikita, thank you. Just which is this? Yeah, this. What is deemed conveyance? Anyway, I will share with all the people who are attending this webinar. So I just request you, those who attended, I will get this slide. Don't worry. Okay. So when it comes to deemed conveyance, yeah, there is someone has raised their hand. Rakesh, just check what is that.
Yeah, Advocate Manjusha and Ibrahim, they have raised the hands. They
Yeah.
can unmute and please ask the question.
I think you will have to unmute them, Rakesh, they won't be able to unmute themselves.
I think, yeah, they can unmute.
Yeah, this is Manjusha here. That was probably done first time before we started something. We were waiting for the this conference to start. That time I had raised, not now.
Okay. Ibrahim. Any question, Ibrahim? Okay, sure. We'll proceed. You can ask later on also, Ibrahim. Okay. Now, what are the steps in getting deemed conveyance? What I told earlier, that deemed conveyance is a conveyance which is given to you by which is executed by deputy registrar or from the registrar, authorized person from the registrar's office. Registrar, I mean to say, is registrar under the Cooperative Society Act. Right. So now, what are the steps in getting deemed conveyance? There are 4 steps for the deemed conveyance. First step is to get an order of deemed conveyance from the registrar or competent authority. That is the first step. So once it gives you order, the second step comes of adjudication of the deemed conveyance. Adjudication means what? What is the stamp duty which is required to be paid on the document of deemed conveyance will be decided in adjudication. I'm going to take all these steps one by one so that you understand all. Thereafter, the steps come registration of unilateral deemed conveyance. And final steps, making changes in the revenue record. Deemed conveyance, if you say it's a simple step, and it could be also complicated step, not everyone's cup of tea also. I will explain you why. If it's a standalone property, one building, one property, there is not much complication in that getting conveyance. So it's everyone can do it. Not you don't require any expertise. But if on the property which is under some scheme where there are multiple buildings, multiple societies, then you require proper understanding about the development regulation. You should understand proper concept of FSI, TDR, how the construction is done, how the FSI is distributed. So all those things you require while I'm making an application for deemed conveyance. So for that you require actually expert knowledge. We'll come to that also, which we are talking about. So now first step, we'll discuss about the first step for getting the deemed conveyance of the property. So what has to be done? What is the question? What is the advantage or disadvantage of deemed conveyance? There is no disadvantage, Ibrahim, of deemed conveyance. If you are not got your property conveyance, you are not owner of the property. It is Sripat, the conveyance supposed to be completed within has to be done within 4 months from the formation of the society. And there is no time limit. You can make application at any time. Okay. Now let's understand what is the first step for making application. That is making an application for deemed conveyance. First step is application to be made for deemed conveyance. Application has to be made to Deputy Registrar of Cooperative Society or Joint Registrar of Cooperative Society for SIDCO area, or it may depend on the change of some other officer also could be assigned that work. So whosoever it is authorized, you can check up with the Office of Registrar where deemed conveyance has to be made. You have to make an application to him for granting deemed conveyance. For that, following step which has to be done. So number one is making an application. Application which is there to be made has to be made in a form 7. It's a format. That format we'll discuss in the course. And it can be made online also and made offline also. But our experience is that often online is difficult. It is not working. Even I tried today also, it was not working. So we will discuss when we are talking about online or offline only. So first is that there has to be an application which is in the format as form 7, which is that to the GR. I will also show that. Just excuse me, just I want to have water. Yeah. So there has to be a application for deemed conveyance. That application we'll discuss later. So along with application, what is to be filed? One is that copy of your registration certificate of the society. If it's a company, if it is a company, then registration certificate of the company. If it is agreed that it will be submitted to the ownership association, then the deed of declaration. So whatever the document which is agreed, which is by under which a association is formed, has to be submitted along with that application. As I told, application can be made offline, online. Then society or company, then there has to be a proper resolution for making application for a deemed conveyance. You have to properly call the meeting. In that meeting, you have to pass a resolution to make an application for deemed conveyance. Then that resolution should also have means a resolution for appointing a person or authorizing a person to execute the deemed conveyance, authorizing him to making application to the deemed conveyance. Just hold on. And to do various other acts like affidavit, all those things, the procedure here, person should be also authorized to execute document on behalf of society. Normally, it is granted to the chairman, secretary. It depends upon you, society. So they should be authorized to do all the work which is required to be done in respect of the cooperative or in respect of deemed conveyance. Then you will require property card or 712 extract, which is not more than 3 months old. You cannot get a property card or a 712 extract which is older than 3 months. Someone, if you get older, they will not accept it. Reason behind that is that whosoever names appear on the property card are required to be made party to the application. What is a property card or what is 712 extract? Extract or property card is basically a revenue document from which government is entitled to recover basically the revenue, the taxes in respect of the property. So the taxes will be recovered from whom? Basically owner. So there is a presumption whosoever names appear on the property card is a owner as per government record is concerned, but he is not a conclusive owner, but there is a presumption. So when you are making an application, a property card should not be more than 3 month old, and you will require to make them also party to the application. Then, along with property card, you will have to make a list of all flat purchaser, giving all details about flat purchaser. Suppose there are 20, I am just for discussing randomly, I am taking that number, sorry. So you will have to name, if there are 20 flats, flat number so and so, his name. If there are multiple transactions which has taken place, then you will have to accordingly make a proper chart of it. Then document, then you will have to make a column, the date of registration of document, stamp duty amount paid, and copy of index 2 also. So it's not necessarily indexed to all document you have to apply, depending upon the which registrar it is. They may sometimes insist index to all, but that issue will be taken up when you are going for adjudication. So that is first part which you have to follow: proper name, stamp duty paid, the date of registration of the document, so that you understand who are the member of the society. So that is number one document. Another document is before you make an application, you have to give a notice to the developer about your not about your demand for making conveying the property. If he doesn't convey after your demand notice to give a conveyance, then only you can make an application for deemed conveyance. So you will have to annex the notice which was served upon the promoter. And if he has replied that notice, even the reply to that notice should be attached to that. See, understand this always. Don't conceal anything from the court. Registrar, when he is deciding this application, he is doing adjudicatory function. Understand this. So don't conceal anything from him. Go with clean hand. Disclose everything. So if you are issuing notice is mandatory. If he has given a reply, even that you annex. Then next comes a commencement certificate and occupation certificate issued by the local authority. If you do not have, there were instances which was taking place that in many of the building occupation certificates were not there. For that purpose, then government modified the rules so that in that case you can give a declaration that we are in possession, possession. If any action is taken against by the local authority, that is municipal corporation, we will not hold you responsible, or we will not claim anything from you for that purpose. So basically, a declaration has to be given by the given when we are making an application for the deemed conveyance. Then the most important topic is if there are more buildings or more than one society in a layout. In that case, let me see whether I am listed out. Okay. So when there are more than one building, even otherwise, you will also require all the societies within that layout to be made party to your application. And you will also require an architect certificate to extent how you are entitled and how much you are entitled to. Suppose giving an example, if there are 4,000 square meter of land and there are 3 buildings on that, one building has consumed, suppose just for our discussion, is 12,000 square meter. 1,200 square meter. Another building has consumed another 1,200 square meter, and the third building has consumed 1,600 square meter. Just randomly I have taken this figure. I am not going by way of any rules and regulation, development regulation, because under the regulation then you will have to give open space and all those things. So I am not going into that. So there are 3 buildings in respect of which 3 separate societies are there. And only one of the societies make an application for conveyance. So how much area suppose an application is made by a society having 1,600 square meter, other societies have not made application, or rather they are not interested. So now what are they going to do? So now the procedure will have to be that when making an application, you will have to annex an architect certificate who has properly seen the approved plans. If approved plans are not available with the society, you will can take it from the local municipal corporation, and you will have to make an, if it's they don't give it, then you will have to make an application under RTI Act. So an application should be then accompanied with the architect certificate. So now when we are talking about multiple building, what would be the ideal way to do it is that the conveyance will have to be such in which you are granting conveyance of the particular building along with the land on which that building is there situated, and proportionate area into the entire property. So what is the how it is? Number one is, this is what a technical aspect is for the conveyance. That is where all problems are created. Even just day before yesterday, I had a client, some abstract area was conveyed to him, and I have many such experience. Just to share one experience, I know one society where there is 20,000 square meter of land, rather 20,000, I think 16,000 it has become. And there are 20 societies. Every society made application, separate application, and every society got a conveyance certificate and also document executed for 2,000, around approximately, I'm talking approximately 2,000 square meter. An architect had given the certificate on the basis of constructed area. So there are 20 societies, 2,000 square meter, everyone is having. So the total land as per the deemed conveyance is 40,000 square meter. And the land on the site is only 2,000 square meter. How is it possible? It is not possible. So whose land is where and 2,000 square meter? No one is able to identify it. So they are not able to complete. They are even 712 extract. So that is the reason when this kind of document has to be prepared, you require a proper expertise and understanding about the topic. So when such kind of things are required, what you have to do is, number one, taking our own example, 4,000 square meter land, one society having 1,600 square meter made an application. When they made an application, so what should be done in such circumstances is that on site property where that building is there, that building along with the land beneath that should be, depending upon how the structure is, basically maybe whatever the land appertinent to that should be conveyed. Number one. Number is building plus land appertinent to that has to be conveyed. Number two, proportionate area in entire property. What is proportionate area? Taking this 2 or 12,000 square meter, and this is having 16,000 square, 12,000, 1,200 square meters, 1,600. So approximately this society should be entitled to around 40% of the total area. So 40%, I'm just random figure. This is 14, 20, 36, 30, 32, 32 plus. I think 36% it will work out. Not. I think 36 or 40%, whatever it is. 40% area in the entire property, undivided 40% area in the entire property. Plus, what there will have to be there, right of way, and whatever, if there are clubhouse and all those things, undivided right in all other common amenities. So when making such kind of application, you will have to be very clear about understanding how the process has to be followed. That is where your expertise comes. That is where the expertise about architect comes, how you are going to do that kind of conveyance. Let me tell you, it is not easy. This kind of conveyance requires a lot of expertise, a lot of understanding about the property law, right of when there are multiple issues are involved. But let's now, just I am told you this is the brief how it has to be. Making that drafting of document is requires another skill of such kind of deemed conveyance. So when you have multiple building, you be extra careful. Otherwise, everyone registrar gives you make a application, and often I have seen the registrar giving an order of deemed conveyance. So that is number one. Now you made an application for deemed conveyance, and there could be in certain places there could be also a plot where it is divided, so there is nothing, no connection with each other. In that case, again the formula will have to be same. Then you will have to verify what is the consumption of your land on the FSI consumption. That is what again a technicality will be involved. You will have to check out what is the consumption, what proportionate area has been consumed in your building, and whether you are getting that by way of conveyance. It is case to case basis. You will have to understand about these deemed conveyance, your entitlement to get the property conveyed. Okay. So when there are multiple societies, you will have to make all societies also as a party and also landowner. So now next. If I told you earlier itself, if there are no occupation certificate, a self-declaration. Just hold on.
So a couple of questions are there in the chat box.
Okay. Yes, yes. I'll just a minute. Let me complete that, Rakesh, and I will take that. Then
okay.
I will take that also. Let's finish that topic. Thanks, Rakesh. If I told you earlier, if society doesn't have occupation certificate, then self-declaration that actual possession of the building has been taken, and similarly ready to accept the responsibility and liability regarding the said building from the any local authorities. If deemed conveyance is granted, the declaration will have to be given, and then a court fees of ₹2,000 will have to be paid, and a self-declaration, rather an affidavit declaring that whatever is stated in the application is true and correct. So this is the procedure basically which will have to be followed while making an application for deemed conveyance. Now, if you have any question, let's go to question, and after that we'll go ahead, understand rest of the procedure. Yeah, Rakesh, what is the question? Manjusha Kudria. Manjusha, sir, if OC is not issued by the developer, is OC and execution of conveyance related in any way? Yeah, I explained you, Manjusha, just now that if OC is not available, you have to give a declaration. Understand this, according to me, no, it is got nothing to related. What by deemed conveyance, what's happening is that building and property is conveyed to you. So you are going to get that property transferred to the society. So technically speaking, it has got absolutely nothing to do with whether the building is legal, whether it's illegal. It has got nothing to do with it. But then what has happened is that because it is under MUFA and all those things, this issue had come. So OC has got nothing to do with it. So even if there is OC, you can get deemed conveyance done. And now they are made clear about it. Tanya. Now, sorry if I pronounce wrong, just excuse me for that. See, if under agreement, if it is stated that you will grant a lease of 98 years to the society, then I have not come across any such thing. Then technically you can't ask other than that. So you will have to restrict yourself for the lease. Maybe you can work out on that for making application for conveyance sale only, looking at the object of the MUFA and now RERA. But what is happening is that some of you might be aware that in the area of New Bombay, CIDCO gives the lease of 30 years or 40 years or 60 years. So government is giving lease of only 60 years, which according to me is wrong. And maybe that issue this issue will have to be challenged by a FRIT also at some point of time. You may have to work on that when it comes to your actual matter. Anything else, Tanya? Tanya, please, suppose there is one plot. Who is this admin to everyone? Sir, suppose if there is one plot on which 2 to 3 housings are there, can society can one of the halt others here no, they cannot stop. They cannot stop. If one society is there, 3-4 society, everyone actually should go for a deemed conveyance. But if they don't go, others can always go for deemed conveyance. And the process which I told, the conveyance will have to be a bit complicated document that will have to be got executed from the office by executing a proper document. Then what is Abraham's question? We are in the complex of 4 individual society in the same complex. Plus there are a lot of common which is jointly used by all buildings. Can we apply for? Yes, Ibrahim, you can do that. Anything else? Vijaya is asking if what happens. What happens if no society is formed? If no society is formed, first step will have to be there. First step will have to be there is formation of the society. Yes, Narayan. If from the order of the registrar, depending upon what order he passes, there is no provision as such for appeal. You can file. You will have to file a writ against the order if it is not to your satisfaction. Tanya, there are a lot of such orders are there. If Vijaya Builders is not encouraging, it's not builder has to encourage. You have to assert your right. Yes, yes, Manjusha. Okay, anything else? Any more questions? So can we proceed further? Yeah, something is there, Nityananda. Whether deemed conveyance will be approved by the competent authority if there is a court case filed by the landowner against the developer. See, that's what I'm saying. This will depend upon case to case basis, what is land and all those things. Many issues will arise in that once you understand what that. See, let's take, I will give an example. I will give an example. In complex, at one part of the society, in that property, the builder is saying that I am entitled to do construction on that property. Society is saying no, entire property is ours. So whether he is entitled to construct that property or not, who will decide? That will be decided by the court. And remaining property, absolutely there is no dispute. So in such circumstances, what I will always suggest is that get the conveyance completed in respect of undisputed part, and whatever that disputed part, let the court decide it. But for that purpose, don't stop undisputed conveyance of undisputed part. So it will depend what is actually your issue is that, and then you will have to tackle according to that. Okay. Nityanand, anything else? Okay, what is this? Initially, there was one society. Builder got FSI and constructed one more building and got society registered. The common area, including entrance, is common. Now, newly constructed society wants deemed conveyance, but also it does not want deemed conveyance separately. Can the society raise the objection? See, I don't know who is this admin. I don't know. Hey, you write your name also, so I understand, so that I can address you accordingly. See, understand this. It is always better when there are when there are less than 5 societies, that you form an association and take collectively one conveyance. And that in conveyance, you can always put which property, what is the proportion of the property each society is having in the entire plot. So it will be more convenient for everyone to put it properly, do it properly. That to certain extent, you will have to work a lot on such kind of conveyance. But yes, it can be done. So there is nothing that one, so that is what the whole problem is. You will have to work out what is the proportionate FSI consumed in a particular building. See, you will have to see what has to be done when you are going for redevelopment of a building. I just the example in which I gave you now, where one is 1600, 1200, 1200. So tomorrow, suppose reconstruction or redevelopment starts. So when that redevelopment starts in that entire property, all property, suppose for combinedly amalgamating and going for, it's amalgamated property only, are going for redevelopment. In that case, what happens? When what proportion the entitlement of each society will have to be decided by the consumption of FSI. So that will have to be studied properly from the approved plan of that particular building. Okay, Santosh. Okay. Yeah, got it. Please clarify. What is that? Sorry. Vibu, what is the please clarify for building built on plot which is a sublease and original owner is dead and no heir. See, you will have to file a suit that for declaration. If original owner is that, nobody is there, no legal heir. See, technically what happens when there is no legal heir or anything, then if I'm not mistaken, that land becomes government's land. I think it is there in the Maharashtra Land Revenue Code. I think so. I'm just not very sure, but 99% yes. In that case, make an application and you may have to make government a party to that on basis of this. We'll also cross verify. Rakesh, remind me, Rakesh Pallavi, of that.
Okay, sir.
And then you will have to make an application for deemed conveyance. Okay, what is Manjusha's deemed conveyance is obtained when developer can't be traced and yes, expired. Yes, you can make application. Anandan will share with you, don't worry. Developer was a lessee of collector land, developed a plot, but not conveyance. Can the deemed conveyances? See, it will depend on what basis, Grishma. It will depend on what basis collector has given permission. And I think now they are converting those land which are converting to freehold land by charging some amount. And I think that notification has been extended up to next month, something like that. That's what I read yesterday in the newspaper. So basically we'll have to get, when it comes to land, there are basically two kinds of land. Just hold on. So basically there are two type of land. Basically one is class 1 and class 2. Class 2 is basically non-transferable land. Actually three types of land. Other is government lessee, but we are not talking government lessee because it's not transferable land. But these are transferable land. There might be some restriction on transfer of the land. So depending upon that, you will have to make an application to the government to make it freehold land. And for that purpose, they are charging particular amount and on basis of certain calculation. Now you will have to make Grishma, that you will have to make and this thing. It will also covered on the deemed conveyance. Conveyance in one transfer of property one person to another. Technically, even lease is a conveyance, even mortgage is also a conveyance. Gift deed is also conveyance. Deed of exchange is also conveyance. But when we tell that mortgage is a conveyance, then it is attached with particular certain restriction. I mean to say property is conveyed, but it has to be again reconveyed to the owner when it is a mortgage deed. When it is lease, so owner has reserved certain right to himself and pass certain right to the lessee. So it is also a conveyance. Lease is also a conveyance, but in that case, owner has reserved certain right to himself and transferred it to certain rights have been transferred. Yes, if it is challenged in the High Court and High Court pass an adverse order, you will have to approach Supreme Court. Manjusha, I was replying. Okay. So now we have completed first step of anything more? Utsav. No, if builder is ready, you don't require any permission, Utsav. It is there, Narayanan. It is there. Law is there. That's what MOFA is there. Now you can go for criminal action also under MOFA and RERA also. So there are enough laws. Only is that we don't want to exercise our right. Thanks, Nityanand. Lease land as a subsequent have executed a leave and license for the structure. No, government cannot do it if you acquire the land. Grishma. Okay, we'll go now, proceed further. Any minimum number of flat required for deemed conveyance? No, it's a society who is taking the deemed conveyance. If not, then if society cannot be formed, in that case, you will have to go for apartment ownership, or otherwise you can claim a joint ownership also. Yes, Sripad. Both action are on for separate reason. You can file a criminal action also, criminal action also against the developer under the MUFA for not conveying the property, and at the same time you can also make an application for the deemed conveyance. No, chain of document will not be required for deemed conveyance, sir. Sripa, technically one way is that even an individual person can also invoke when it comes to criminal proceeding against the builder. You can also invoke, because you are a flat purchaser, you are exercising your right under the MUFA. So you can also, a single person also can technically invoke the criminal provision under the MUFA. But only the issue is that how much you are a person, one person fighting and collectively fighting against the developer who has got all resources is totally different issue. Okay, rest of the questions, if you are, just put it on the chat and then we will discuss it later on. Okay, so first step which is required to be done, as I told, is making an application for conveyance. Then in that application, who are required to be made party to that application? One is that builder will have to be made party, number one. Then all persons whose name appear on the 712 extract will have to be made party. 712 extract or property card, depending upon the whatever property is. Or if there are both, I have seen both also in certain cases, which should not be there ideally, because once a property becomes NA, technically 712 extract should go and property card should be created. But I have seen at times both property card also, 712 extract also. So whosoever name appears on the property card or the 712 extract, they have to be made party. And as I told you, if there are more than one society, all societies in the layout in respect of which the approvals have been obtained should be made as a party to such application. So when these applications are made, registrar will hear all parties. If party doesn't appear, registrar will ask you to issue a public notice, and thereafter he will finally decide the application. Normally it is granted, or if you are not satisfied, suppose you make an application for, if it's a combined this, you make an application for 4,000 square meter and he grants only 3,500 square meter. Then if according to you, on the date when your approvals were granted for your building, if all FSI or development potential is consumed, then you are entitled for whatever additional development potential is there. Means suppose the day, just take an example, that you agree to purchase a flat in 2010, and development permission which was allowed applicable was there 1 FSI. one FSI was permitted. So suppose 4,000 square meter, he has developer has consumed that 4,000 square meter and he has completed your building. Suppose there is a change in regulation and FSI which is permitted is 1.5. So that addition 1.5 means he can construct 2,000 square meter more. But that will not belong to him because at that point of time it was not permitted and he was supposed to do the conveyance of the property which he has not conveyed. That FSI will belong to the society and you will be entitled for that conveyance. So on the day in which the permissions or you agreed to acquire the plot, you will be entitled as per your agreement. So it will all depend on case-to-case basis on what is reflected in an agreement. So normally, if it's giving you less area, then you will have to challenge it by way of writ. But you will be able to do it only when you have put your case in writing properly in your application for deemed conveyance. That is where the expertise comes when it making application for deemed conveyance. If you make a standard application, you may not have any case when you go into writ. So I always suggest make proper application. At time, even if a registrar rejects your application, in that case, you should be able to carry it into writ and certainly you should succeed in the writ in the High Court. So first step which we have now completed is you have got an order of deemed conveyance. That is the first step which you have completed. So now second step, now is second step is adjudication of a stamp duty. So whenever a document is required to be registered, you have to pay stamp duty under the Maharashtra Stamp Duty Act. For in my mouth, it is always Bombay Stamp Duty Stamp Act, because when I started my practice, it was Bombay Stamp Act, and I think 2013 or 14 there was a circular or a resolution passed. All those acts which had a Bombay in front, like Bombay Public Trust Act, Bombay Stamp Act, there are many, I think hundreds of acts which had a Bombay in front, were named as Maharashtra Stamp Act, because then we were known as a, earlier was it's a Bombay state before 1960. So many of those acts are named under Bombay Stamp Act. So whenever you are making an application for, whenever you are registering a document has to be properly stamped. So now your deemed conveyance is ready, deemed conveyance prepared. Now that deemed conveyance has to be properly stamped. So when stamping is concerned, the stamp duty is as per the Bombay Stamp Act, sorry, it's again coming Bombay, Maharashtra Stamp Act, and that will be on the stamp duty which is applicable on the date of executing a conveyance. So at that point of time, stamp duty will be calculated on basis of the stamp duty applicable, and for that purpose, you will get set off of stamp duty which is paid by the flat purchaser. Understand this, if all flat purchaser have paid a stamp duty and registered their agreement, then there will be no difficulty. Maybe you may not have to pay any additional stamp duty. But if some documents is not registered or they are not paid the stamp duty or there is a deficit, something like that, in that case, you will have to pay the deficit stamp duty and get, for that purpose, a document of deemed conveyance has to be adjudicated from the office of collector's office, deputy registrars and collector's office. You will have to adjudicate the document which is done. At that point of time, they will ask you to submit all index 2s, because index 2 will reflect the stamp duty which is paid by all flat purchaser. After that, the collector of the stamp or whoever the appointed officer will finally decide what stamp duty is to be paid by the on the document of deemed conveyance. So if a particular person has not paid stamp duty in respect of that, the GR which we will be referring to very clearly state the person who has not paid the stamp duty will have to pay the stamp duty in respect of the deficit which is attributed for his non-payment. So this is the second part. Again, I'm going to that. Is second part about the adjudication of the stamp duty. Yeah. Any questions on this? I can see something on the chat on this. Vibhu, stamp duty was not applicable. It's a this thing. It's not correct position actually. Stamp duty was always applicable, but you were, I think, up to 90s or late 90s, no 80s, late 80s. Nobody was registering and nobody was paying stamp duty. Stamp duty was always applicable. So stamp duty was always applicable. So now just we'll go one by one. Basically, Grishma, stamp duty is on the land, and they calculate stamp duty on the potential of the land. If there is a potential land of the land, suppose only potential of the land on date today, you mean to say that property which is there, only one FSI has been consumed and potential of the land today is 2 FSI or 1.5 FSI. On basis of that, stamp duty will be calculated. They are circular, and if you can also see that stamp duty calculation circular is also issued by the stamp department, you will get the method how the stamp duty is calculated. If no index 2 available, there can't be Utsav. If document is registered, there can't be that no index 2 is available. Index 2 is there. If a document register, in that case, there will be index 2. You can check what is the index 2 in the Registration Act. Yogesh, how about unsold flat still owned by the developer? For that purpose, the deficit part, developer will have to contribute for the stamp duty. Viva, I can't say how much it will be applicable now. It is a today. It will be today's rate, so I can't say anything of now. If not registered Utsav, then the deficit stamp duty will have to be paid. Okay, anything else? Just hold on. Yeah. So second step is, okay, what is that, Raju? Flat using by builder for his office use, then we stamp it. See, whatever is a deficit, whoever has not paid will have to contribute that towards that stamp duty. If it's a builder, then builder will have to contribute for the stamp duty. Okay. So second step, which is that you have got your document adjudicated from the stamp office. Now, next step comes is step number 3 is registration of document. Once that is done, you have to register the document in the office of sub-registrar. So now all problems are solved. Deemed conveyance you become a owner of the property. The real problems start after deemed conveyance. In case of multiple societies, multiple this thing, if it conveyance is not done properly, then where the real problem starts. Because fourth step is to add your name in the revenue record. The moment the question comes, making an application to the Talati or whosoever Talati application, then Talati will seek a document on with basis of which you are claiming an ownership, and then he will check whether it's a proper, which should be, what should be the survey number, what could be, all those things will start after that. That is the reason your application and copy of deemed application has to be proper, proportionate area, and all those facts which has to be captured in that document. And then that is how even Talati will have to thereafter record it. And till now, I have not seen any revenue record which captures this in a proper manner. Probably even they have not realized this happening. And because most of them even don't go to the Talati for making changes in the revenue record. They stop on the step 3 itself. Step 4 is very important step, because that is how your name will get recorded in the 712 extract. So the most and important step, just hold on, most important and final step is getting your name recorded in the 712 extract. For that purpose, if you have made a proper application, then there will not be any difficulty. Right. So this is what basically a process which is to be followed for deemed conveyance of the society. So now this topic is over. We'll go through the GR. They have given an application forms and all those things in that GR. So how we have to follow, we'll just go through that. If you have any questions up to now what we have discussed?
Sir, I think there is one more question from Narayanan. What is the fate of unsold flat that is indexed to in the whole process of deemed conveyance? So
What
index
is
to
the
basically
fate
for
of
the unsold flat, that's what
that is
asking.
indexed to in the whole process of deemed conveyance? Narayanan, index to is basically required because index 2 is basically required because from index 2 the registrar comes to know what is the stamp duty which is paid. That is the only reason why index 2 is required, nothing else for purpose. So he'll verify what is the stamp duty which is paid.
No, I think what he's trying
And
to
if
ask is for the
flat,
unsold
there
flats.
can't be index, huh? Sorry.
Yeah, for the unsold flat, what they should produce.
Unsold flat, in respect of that, the developer will have to contribute towards the stamp duty.
Yeah.
Sripath, yes, can just a minute. Can conveyance be challenged? Yes, I told when conveyance is already done, if it has gone into writ, then it will depend on the outcome of writ. But if I am not mistaken, in one of the matter, court told in that case you file a suit. So it will all depend case to case basis. Yeah, Manjusha. Rakesh, can you unmute Manjusha? She is requesting for unmuting her.
Hello.
Yeah, Manjusha.
Yeah, thank you, Rakesh. Sir, just to whatever I have understood as of now, I would like to summarize it and please correct me if I'm wrong.
Yeah.
Sir, when there is a builder and he is willing to give us conveyance, so go for the go to pay the stamp duty, go to the registration office, adjudication of after adjudication of stamp duty, go to the get the conveyance draft, conveyance deed drafted, go to the registration office, get it registered, and go to the property, get the name in the property card endorsed. Builder is willing. Second, if the builder is not in second scenario, if the builder is not traceable, then we have to go through the registrar.
Right.
If the builder is not traceable or suppose dead, then we have to go through the procedure of registrar, which you elaborately explained to us.
Right.
Now in this case, it may so happen the once we get the order of registrar, the legal heirs of the builder may come and challenge it to the in the high court, which we will have to definitely fight till the logical end. This is second scenario.
Right.
Yeah. So the first scenario is if builder is agreeing, go for it. If builder is not traceable, then go through registrar, which may be and ultimately challenged.
Right.
And the third scenario is builder is disputing, where he is not willing to give at all the conveyance. In that case, we have to fight it till the Supreme Court.
Right.
And so,
Right.
yeah, in that case, when the builder is not willing to give the conveyance, either we can go through consumer courts, or can we go, what would be the jurisdiction to High Court? Considering all the flat and land amount, we can, because High Court jurisdiction is above 1 crore. So can we go to High Court instead of going consumer courts? Because High Court and then Supreme Court immediately. Here in consumer court, yes, sir, please.
Yeah. See, you can see you have a right to go to the, file any civil proceeding. That is unconditional right.
Yes.
The right under consumer court or deemed conveyance is an additional right which you are given.
Correct.
When you go to the High Court, the time it will get, I am not aware now which years suits are coming. You may take 20-25 years. No one knows where we are going to be there after 20-25 years.
Yes.
So it is not advisable when there is a provision which is given, which is more simpler and easier. And for addressing the problems which are there.
So consumer court is the better option.
Consumer means deemed conveyance is the best, because thing is that provided you have put your case properly.
No, sir. No, sir.
I think that applications are made properly. I am seeing the applications are terribly made. Terrible. I mean to say terrible. Means it is not made properly at all. Then we need to take that kind of order to the writ court. Writ court is not a fact-finding court.
Yes.
Writ court is not going to get into those disputed this thing.
Yes, I agree. It is a faster remedy.
So it is always advisable to go for deemed conveyance, make a proper application for proper understanding. And unfortunately, that is what the whole issue is. And then go for writ. So writ court will decide it. If writ court decide on this proper, on some issues, that send it back. It depends case to case basis. I think just few days back also one order was passed, which not few days, around a few months ago, that go to the civil court, let the civil court decide something like that.
Okay. Now my limited question, sir. Now my limited question is, if builder is not agreeing for the conveyance, so can't go for the deemed conveyance. If he's not agreeing, so how can we go for the deemed conveyance? In that
Yes,
case,
when builder is not agreeing, then deemed conveyance you have to make. Registrar will decide that.
okay, okay, I got
Registrar will decide it. That is why deemed conveyance. The builder will represent his case over there. Why you are not entitled to? On that basis, the registrar will have to decide it.
And any order against our favor, if our order is unfavorable to us, we can go to the High Court.
Then you carry forward in the
Writ petition.
by way of writ.
Yes, which is faster remedy. I got it.
Yes. Okay.
Thank you.
Okay, okay. Yes.
Thank you.
Yes.
Thank you.
Welcome. Ek minute. Now, Sripad, in your case, developer has approached High Court to challenge conveyance order of one of the society. Yes, if a order is not satisfactory to the satisfaction of builder, he will certainly go. But if your application is proper, Sripad, I am replying your question. If your application is proper with all proper calculations and everything, that is what whole skill comes, then I don't think court is going to interfere it. But if your application is not proper and registrar has not decided some issue properly, then he may direct that let it come down before again to the registrar. I think, did I reply it earlier, Sripad? I don't know. Okay. Now, Raju Mahendarkar. Okay. Do you have to pay additional charges or duty while transfer of document on the revenue record? You will not have to pay additional charges or anything for any additional charges or any duty while transferring your revenue record. Raju. Isra, I don't know whether I'm pronouncing properly. There is no sound, can't hear anything what speaker. I think just check from your end. I feel, does anyone has a problem with the sound? I don't think so. Vibhu, basically when agreement is executed, in that case, index to UCAN is always available with the registrar office. And your agreement is available with the registrar's office. So there should not be any difficulty. It cannot be held up for that. Vijaya. Rakesh, can you unmute Vijaya?
Hello, can you hear me, sir?
Yeah, Vijay.
Sir, the question I had asked you earlier with regards to the formation of the society is, in my case, the builder has not yet formed this. He's not supposed to form the society. I agree, we have to assert it. But the problem is,
he is supposed to file it. He is supposed to form it.
No,
it is
yes.
his obligation.
So when you said that we need to assert, I think that's not really happening in our case. And therefore, my question to you is that can I, as an individual owner of that particular place, file for deemed conveyance?
See, deemed conveyance is granted in favor of society. On that issue, I have some different thought on right of the flat purchaser and a proportionate. That is a separate this thing. I will share it on the group.
Okay.
You alone cannot go technically because thing is that society has to ask for deemed conveyance. And if you are asking me other question, according to me, and RERA has explicitly made it clear that you have a proportionate right in the property, in the conveyance. And I will put that my writing on that, share with you. So that is a different topic. Again, we'll be going into another topic. But as it stands today now, you cannot go for deemed conveyance. But if it is a RERA registered, then you can go for make an application with RERA directing him to register the society.
Okay. Another question is, that you
Yeah.
had said, you had talked about paying of stamp duty, and there's going to be an index 2, and if there's any deficit, then the developer has to pay. Question to
Developer
you
has
is,
to be
have
developer
to
has
pay
to
for the
pay
unused flats, the unused flats.
unsold flat.
Unsold flats, sorry. So question to you is, now suppose if there is a certain amount, and after setting off all our whatever the flat owners amounts are, there is still an amount which is left, then what happens?
In the sense, I didn't get you.
No, so there is a stamp duty which is applicable for a particular land which I have to pay, and because of which there's an index 2 wherein all these names are put in and the amounts are set off against that amount. Am I correct?
You're right.
Right. So if there's any still amount which is left, which still has to be paid, then what happens?
That has to be paid by society.
Okay. Okay. All right. Okay. Okay. Thank you. Thank you.
Yeah. Okay. Welcome. Now what is it? Narayanan, people don't want to do anything themselves. That is why there is a poor response, very unfortunate one. Manjusha, normally I have seen within a year or so, normally it happens. It gets completed. Depending upon registrar.
Hello.
You see?
Hello.
Yeah.
Yeah, Mandar here. My question is, actually we have gone for the.
Rajesh, some sound is coming from someone.
1 second.
Well, just check who it is. What is your name? Who is talking now?
Hello. Yeah, Mandar here. Is it clear now?
Yeah, but not from you. Someone else outside, I believe. Someone else. Noise from someone else. Okay, yeah. Nandan, no? Who is that? Yeah, please speak.
Hello.
Yeah.
Sir, can I speak? Meanwhile, the other person is.
Yeah. Who is speaking? Manjusha?
Yeah, this is Mandusha.
Oh, yeah, Manjusha.
Sir, there are two. There are two types of stamp duties here. If please correct me. The people, the flat purchaser who have not paid their respective stamp duty while buying the flat, that we have to pay. That every flat purchaser has to bear and
that
pay.
Particular flat purchaser has to pay.
Then again we have to, the society has to pay from its funds the stamp duty on the land, on the amount of land,
on the amount of
present market value of that land.
Yes. If there is a deficit, see, one stamp duty will be if there is a deficit reduced because a certain flat purchaser has not paid or a builder has not sold the flat. That is the one part is there. So we have identified a particular person who is liable to pay. Then other part will be that it's a collective responsibility of the society. The society will have to pay, and thereafter, suppose that particular flat purchase is not paying, is not paying, in that case, society should pay, get the document registered, complete your deed of conveyance completed, and then you fight with that particular person, add it to it maintenance and create a document for recovery.
Now, sir, my question is, yeah, I got that. Thank you. My question is, like, every flat purchaser has to pay the stamp duty for his respective flat.
Yes.
Okay.
Yes.
Then again, do we have to pay second type of stamp duty on the because the land is going to get conveyed in the name of the society? So do we also have to pay the stamp duty on the market value of the land, present market value of the land?
Right. Yeah. Stamp duty is calculated on the date of execution of the document.
Yes.
So you will have to pay the present market rate on the stamp duty. And elaborate
for the land value.
For the land value. They have elaborate discussion on the how the stamp duty has to be calculated in the ready reckoner's circular. They are for different parts.
Yes, I got that, sir. Every flat purchaser has.
Yeah.
Yes.
What is that?
Every flat purchaser has to pay that. completely. Every purchaser has to pay his part of stamp duty,
Is
which is understood completely by me. However, my question is like, do we need to pay the land stamp duty on the amount of land, because the land beneath the building must be having certain value, right?
yes,
So do we need to pay the stamp duty on that amount of land as well?
yes, you will have to pay.
Okay.
Without
Yeah.
that, document is not going to get registered.
Okay. And that stamp duty has to be borne by from the society funds.
Borne by the society. End of the day, society is not in any business. So end of the day, it will be collected from the members of the society.
From us. Yes, correct, sir. Yeah. Thank you
So
so much.
that then will have to be formalized. What is the percentage of members is having, and all those things exercise will have to be done. This is all case to case basis. Okay.
Correct, sir. Thank
Can
you.
society file consumer complaint? That is the question of Neelam. Yes, Neelam, consumer complaint is also maintainable. You can file it, but then there is a limitation. Here, elaborate process has been prescribed for deemed conveyance, and it's much easier compared to going to consumer court to go to the registrar's office and get an order for deemed conveyance. So I will always suggest go for deemed conveyance. Once more, please unmute. Manjusha has yes already. Can society and consumer individual member file? Yes, individual member can file in consumer also. Please send me remedy for non-formation of the society. Remedy is what Vijaya is to file. If it is RERA, you file a complaint with before RERA authority. That is a remedy. Or you can go also consumer forum also. Yes, Vibhu, I think Rakesh, can you unmute Vibhu?
Hello, am I audible?
Yeah.
Yeah, thank you so much. My question is in continuation to my earlier question regarding the availability of agreements. So, as I told you, in 1975, the registration was probably not done by a lot of people, and hence the probability of getting a copy from the registrar's office would be very difficult. So, in case we have a situation where an agreement is not available with the society, will the deemed conveyance get held up? Because I believe you have to submit a copy of all the agreements with your application.
Understood. It will not be held up. Only thing is that you will have to pay the stamp duty.
I see.
You will have to pay the stamp duty, because then there will be presumption that document is not registered.
Okay, so wherever an agreement is not available, based on the area of the flat and the market value, the stamp duty will have to be paid by the society, and then the application can move forward.
Right.
Am I right? Okay. Thank you so much. Thank you.
Okay. Okay. Now we'll just go through the this thing. Just cursorily go through anything else. Netra is procedure, just hold on. Netra is procedure for deemed conveyance of MADA and as same. See, MADA, SIDCO procedure is same, only the application has to be made before different authorities. Same procedure will be same. Whether RTI can help for obtaining document from where? Yes, Narayanan, yes, it will help you. That is the best.
Hello.
Yeah.
Yeah, Mandar here. Yeah. Actually, we have gone for the redevelop this deemed conveyance, and we have already applied. We have got.
Yeah, our voice is low. Can you just see that because it's becoming low?
Hello.
Yeah.
Hello.
Yeah, speak. Yeah, speak.
Yeah, you clear now?
Yeah.
Yeah, we have gone for the deemed conveyance, and we have already applied, and we got the order also from the registered office to get the deemed conveyance done. Now the documents have gone for the adjudication, and in adjudication they have taken so many queries, and to complete that process is still going on, and it now almost a year it is still going on. So is there any time bound activity for this adjudication and execution?
Actually, it should not take, because it should not take such a long time, maybe matter of month or two. You might have not provided him proper information, or you might have not satisfied his requirement.
But any time bound is there for the
There is
execution?
no
Or
time bound as such. There is no time bound as such. But if you see, there is some act or rule for a government official to decide this thing. With that, it is, I think, 15 days or 1 month. But
okay,
then, if you are provided, you supply all information.
okay. So once the adjudication is done, then we can still go for the dim conveyance exhibition.
By
That
thereafter,
order
you
is
will have to
already.
register the deemed conveyance, and thereafter, you will have to get the changes recorded in the proper this thing revenue record.
Okay, okay.
Okay. So just we'll go through the GRs, that just in 5 minutes, and then we'll stop. If no further questions. Why is this not opening? Just a minute. Just a minute, huh? Just I'm trying to open GR. Why it is not reflected in? I'm wondering. Just give me a minute. I'll let this close this one. Just 1 minute, huh? No, somehow it is not shown. Somehow GR I'm not able to get in the sharing this thing. Why can't I share the GR? Sorry, yeah, got it here. Yeah, there is a GR which is issued in 2017 or 18. 2018. This is the GR which is issued for procedure to be followed for deemed conveyance. So this will give you in detail, particularly some of the issues or questions which were asked to me. One was that if a particular flat owner had not paid, in that case, he will have to pay the stamp duty for that purpose. And even in respect of more than one building, even that is a procedure which is prescribed clearly over there. If separate cooperative society, then each building has to be, each society, all societies have to be joined as a party, and then you will have to explain what are the undivided share of occupancy right in proportion to the construction. So all those things are explained in this GR, which I will email to you. Kindly fill that form which I have put on this, on the link, and only people who have attended this workshop or webinar will get that, not all others. Of course, this is a public document. It's available if you try it. And then the format of application is also given, the way what should be the contents of the application. But this is just a format. You will have to tweak as per your requirement in the case-to-case basis. Then order copy of a sample order certificate of deemed conveyance is also given in that this thing circular. I will share all those things with you. And procedure of registration online is also given in this. So this is what I wanted to tell on the topic of deemed conveyance. we are conducting many such various topics, and next week it's going to be on arbitration, practice and procedure of arbitration. We are lined up many of the topics like practice and procedure of arbitration and power of attorney. These are all going to be of free or depending upon what and what time it is and all those things, many factors. Probably most of them are free only lectures. All are practical utility, like what is minor's right and all, power of attorney, minor right, we are already done on the will. So all those topics we are regularly conducting. So be in touch with me and on this forum. And other thing which I will request is give your proper testimonial. I would like if it's appreciated so that others also know about this kind of topics, and it will be an encouragement for all of us to have more such kind of webinars. If you have any questions now, kindly you can ask me, or we'll stop this webinar. I have to appreciate all of you. I have to appreciate my team member, particularly Rakesh and Pallavi, and I think Pratibha is not there. They help me a lot when I'm organizing this kind of webinar. So I have to also thank you. And I also thank the Rotary Club of Ghodbandar Road, Thane, for taking active participation in organizing this webinar. Thank you for all of you for attending this webinar and making this successful. And I would have appreciated more people joining and understanding what is the deemed conveyance and exercising their right in respect of deemed conveyance. Thank you.
I have a
If you have any
question.
question, please kindly ask.
I have a question. After
Who
the
is
deemed
speaking?
conveyance is done,
Who is speaking?
Ezra Moses.
Yeah, yes, sir.
After a deemed conveyance has been done for a particular society, and one of the flat is sold, has the new owner to add his name into the document?
See, deemed conveyance is in name of your society. So nothing document, nowhere it's required to be added.
The new owner doesn't have to record his name there.
No. Document is deemed conveyance is only in favor of society. So nowhere any flat purchaser's name is reflected in deemed conveyance.
Okay, thank you.
Yes.
Very good show.
Sir, one question, sir.
Yeah. Ask us. Don't worry.
Yes, sir.
Hello.
Of late, I read about the circular or some news, or maybe it was a case judgment, wherein they stated that the name of the flat purchaser will directly come on the property card.
That is something. Ek minute. I know there is something fake news is going on, but I will request all of you give a good feedback on the group, not on this.
Yes, definitely, sir.
Yeah.
Definitely.
This is what, sorry, coming back to this, that is a fake, this thing, but another act which is proposed is Land Titling Act, Land Title Act or something act which is proposed. And in that they are contemplating this procedure. But whatever is in circulation is totally fake and it is not true.
Okay.
That Land Title Act also, if required, you just message me. I will check up. I should be having a copy of it. In that, many things are there in that. Because thing is that dispute occurs often on the who is entitled for land. There is no certification from the authority, which will be coming if that Land Title Act comes into the picture.
Okay, sir. Okay. So I was wondering how come every person will be a percentage of share will be owned by a flat purchaser. That's what I read about.
See, actually, percentage. If you see RERA, I will share that note on this thing group on conveyance right now. Hopefully, this thing on the conveyance. Because law is very clear, you have percentage in the particular property on that. So I elaborately explain that.
Right, but it seems very complicated, sir. Even I was wondering how can every flat purchaser name can be on the property card. It is
cannot be pro bono, but separate property card which is It's not complicated, but whatever they are discussing or being circulated is not true. There is nothing.
Okay. Okay, sir.
Anyone
sir,
else?
Sir,
Yeah.
this slide, may I just know? I would be really grateful to you if you could share these slides with us.
Yes. That's why I told no. Put your name that on that this thing. What?
Group.
No, in that fill the form which is there. So all those who attended them, they will be getting this. Don't worry.
Where can we get that form, sir? I have no
That
form.
is in the group. I have put a link.
Okay.
Hello.
Just let me check if I can put here also.
Really appreciate it, sir. It was really valuable.
Thank you.
Hello.
Yeah, who is that? Yeah.
Mandar here again. One more question is actually we have tried this DIM conveyance earlier also, maybe around 2013 or so, where we got the letter from the registration office how much amount we have to pay for the execution of this DIM conveyance. Yeah, stamp duty. And that actually we have paid, but somehow the agreement could not execute it, and we just paid. We have that receipt. Now again we have applied and it is in process. So once that amount comes to us, how much we have to pay, whether we can adjust the amount which we have paid earlier.
Yes. You will get a set of it.
Okay.
Okay. Thank you. Thank you, all of you. Thanks for attending this webinar. Have a good day.
Very good.
Hello.
Yeah. Someone else?
Sir, उत्सव दोषी एडवोकेट हियर.
उत्सव बोल.
सर एक्चुअली थोड़ा सा प्रैक्टिकल पूछना था इसमें कि
प्रैक्टिकली पूछोगे. प्रैक्टिकली बात करने के लिए यार, थ्योरी का बुक में पढ़ सकते हैं.
हाँ वही. सो एक्चुअली मुझे ये पूछना था, अपार्ट फ्रॉम इंडेक्स 2 और जो एजुकेशन वाला पार्ट है, उसके अलावा एप्लीकेशन करने के टाइम पे what are all other documents which is relevant for this DIM conveyance?
No, पूरा दिखाया मैंने, लिस्ट दिया ना आपको.
हाँ.
बेसिकली इंडेक्स 2 ही है. डॉक्यूमेंट है. नोटिस जो दिया है एडवोकेट अपना बिल्डर को, वो है. सोसाइटी का रजिस्ट्रेशन सर्टिफिकेट है. और दिस थिंग क्या बोलता है, एंड रेजोल्यूशन पास किया हुआ वो है. एंड कोर्ट फीस ऑफ 2000 रुपीज.
ओके. और ये सोसाइटी का सर्वे वगैरह कुछ करने की जरूरत नहीं है उसमें?
नहीं, उसमें आपको आर्किटेक्ट सर्टिफिकेट भी लगेगा. शायद मैंने उसमें लिखा नहीं, आर्किटेक्ट सर्टिफिकेट भी लगेगा. आई थिंक दैट मिस माय दिस थिंग. आर्किटेक्ट सर्टिफिकेट लगेगा, प्रोवाइडेड कि बड़ा प्लॉट है, लेआउट है उसमें.
उस हिसाब से, लेआउट के हिसाब से ही चलना पड़ेगा ना अपने को तो.
हाँ.
ओके. थैंक यू सो मच सर.
ओके. एनीवन एल्स? चलो, बाय बाय. Good day. Happy Holi. Enjoy the weekend also. Bye.
Bye, sir. Happy Holi to you.
Bye. Thank you.
Thank you, sir.
Yeah.